Imagine if the most popular rifle in America, the AR-15, and magazines were declared outside of the 2A's protections. That's not just a hypothetical, that is currently up for consideration in the Supreme Court. And the question before the court is a very simple question. Does the Second Amendment guarantee a right to possess AR-15s and magazines? So let's talk about the news that is happening in these cases and what happens now going forward. Now, before we jump into this video, if you guys want to support the channel, one of the best ways to do that is simply to subscribe. Also double check to make sure YouTube is not unsubscribed to you because they love to do that, especially on 2A channels. Now, as I mentioned in the intro, in this video, we're going to be discussing a critical rifle and magazine ban challenge that went in front of the Supreme Court at conference, and now we have some additional information. The primary case that I want to talk about in this video is called Viramontes versus Cook County. And in that case, the petitioners are individual citizens along with organizations like Second Amendment Foundation. And in this case, they are challenging Cook County's ordinance, which makes it a crime to sell, transfer, or even possess a so-called assault weapon. The plaintiffs in this case argue that this ban doesn't just regulate firearms, it actually outlaws some of the most popular and common rifles in America, which should be protected by the Second Amendment. And that, they say, essentially cuts against what the Supreme Court has already decided in cases like Heller and Bruen, and that needs to be applied against this ordinance and it needs to be struck down. This case also tries to leverage the recent statements made by Justice Kavanaugh after they recently denied review to the Snow rifle ban. That one came out of Maryland. There was a denial last term, and in that denial, Justice Kavanaugh made a statement saying that the time would come soon where they would need to take up a rifle ban, they need to address this issue, and they said that that would happen in a term or two. The plaintiffs now pushed this case as a vehicle to finally fulfill that promise. And the Supreme Court has once again pushed out review of these cases. So we need to talk about what is happening in these cases and what the real list of these cases could potentially mean. Now, first, let's talk about how did these cases get here? Specifically, how did this rifle ban get in front of the Supreme Court? So essentially back in 2021, this rifle ban lawsuit was filed in a federal district court in Chicago. The petitioners challenged the county's ban under the Second Amendment. And essentially in 2024, while the case was pending, Illinois passed a statewide assault weapon ban, which overlapped with Cook County's restrictions. Now, around the same time, the Seventh Circuit actually decided a different case called Bevis versus Naperville, and they upheld Illinois' law, and they essentially claimed that AR-15s were too militaristic in nature to be protected as arms. Now, the district court in this case, this Cook County case, was bound by what the Seventh Circuit said in that ruling, and so they upheld Cook County's rifle ban under that ordinance. Now, the district court issued a summary judgment in favor of Cook County, and essentially back in 2025, right after the Snow petition was denied in that Maryland case, the Seventh Circuit decided to affirm what the lower court said in this Cook County case. And as a result of that, the plaintiffs are now seeking Supreme Court review, and they're asking for the court to finally resolve this issue. They asked for the Supreme Court to declare once and for all whether Americans have the constitutional right to own AR-15s and similar semi-automatic rifles that states and cities and counties are banning. The petitioners argue that circuit courts are split and deeply confused about how to apply Heller and Bruen, and some courts have even gone so far as to say that AR-15s are protected arms, but they still can be restricted, while others are saying that they're not protected arms at all. Here, the petitioners point out that Cook County and the Seventh Circuit rely on the idea that AR-15s are military firearms. However, the whole useful military service analysis, which was used by the Seventh Circuit and some other circuit courts, was never actually a part of Heller or Bruen or any of that type of analysis. Now, Cook County responded by arguing that the court should once again deny review to this whole rifle ban case and kick the can down the road once again. Cook County argues that this case doesn't warrant the court's attention for multiple reasons. First, they say that there is no circuit split on this issue about rifle bans and whether or not they are protected arms. And second, they claim that this case is a poor vehicle for Supreme Court review because they argue the plaintiffs kind of skip some of the basic procedural requirements down below. They, skipped discovery. They offered, in their eyes, no admissible evidence to support their claims. And essentially, in other words, here Cook County is claiming that the plaintiffs kind of rushed the process to get this case to the Supreme Court, and there's not enough evidence for the Supreme Court to weigh in on this issue. So at its core, this case finally asks the Supreme Court to do what we've been asking them to do for many years, which is to take up a state rifle ban and hopefully strike that down. Now, this case originally went to conference a few weeks ago. It went with other challenges like the California Duncan versus Bonta magazine ban challenge, and then also one of the machine gun ban challenges, which was the Morgan case. The Duncan case, you may remember, was recently granted, vacated, and remanded by the Supreme Court after they issued their Bruen ruling. But like other two-way cases, now it's back in front of the Supreme Court because the lower courts are simply not applying the correct analysis, and they're continuing to uphold these state rifle bans and magazine bans and saying that the two-way does not protect these items. Now, both of these cases have been relisted multiple times, and once again, they were relisted again after they went to their second conference. Out of the first conference, they survived, even though the Morgan magazine ban challenge, that one did not survive that conference. They were relisted to a new conference. They went to that conference with a bunch of other two-way cases, including the Rush and Robinson SBR NFA challenges. The Rush and Robinson NFA challenges were denied review after that conference. These ones survived and were relisted once again. Now, that's also potentially a good thing, and you may wonder, why is the Supreme Court relisting this case so important? Why is the constant relist of this good when they're denying review to some of these other ones? Well, that's because all Supreme Court analytics and tracking on prior cases show that a case has a higher odds of being granted review by the Supreme Court if it's relisted, most of the time if it's relisted just one time. In fact, according to the data for the court's 2016 to 2020 terms, between 31% and 43% of the petitions that were relisted at least once were eventually granted review by the Supreme Court. And between 66% and 75% of all cases that were granted cert were relisted at least one time. So the fundamental truth is that a relist just one time is far better for granting of review. Multiple relists could potentially also be good, but when you start to get multiple relists, if it starts to climb in numbers like 3, 4, 5 times, well, then often that could be an indication that the case is often going to be denied, but maybe you're going to have a dissent from one of the justices. So there is still a chance that these cases being relisted twice is not a bad thing, especially since they survived the conferences where you had the machine gun ban challenge after that one get denied, and then also the conference right after that where you had the SBR challenges. In the order list after that week, you had those SBR challenges get denied, but both the magazine ban and the rifle ban survived those, and they continue to be relisted. So if there was no interest in these cases like the other ones, the Supreme Court would have simply just denied review like they did in those other cases. Now, I will point out that the Supreme Court has avoided, to this point, rifle and magazine bans kind of like the plague. However, we will now know soon whether Kavanaugh's promise that they will take up this issue in a term or two was actually a true statement or just another empty promise from the Supreme Court. And we will find out very soon when these get relisted for the official new conferences. All eyes will kind of be on those conferences, which will likely happen kind of in the beginning of January, because as of right now, a date has not been set for the new conference for these two cases. With the upcoming holidays, there's no official conference here at the end of December, but early in January is kind of the first official new conferences that are going to be set. And so I would suspect that both the Vera-Montes case and the Duncan magazine ban case will get relisted probably for that January 9th or early January conference. So that's what's currently happening in these critical rifle and magazine ban challenges that are once again being pushed to another conference for another consideration from the Supreme Court. They're not done yet. They haven't been outright denied like some of these other two-way cases, so that potentially is a silver lining. Maybe there is some interest in these cases. So we're going to have to keep our eyes closely on the Supreme Court in the following month to see what they decide to do in these two cases. So as we get more information, as it develops more, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. You can also check out one of the two videos here on the screen that the YouTube algorithm thinks that you'll find helpful. But as always, thank you so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.